Great. Gazing at the H-1B Powerball. Okay? We're going to get back to some H-1B dialogue, bringing up Poorvi, Chotani, our panel leader, and Manjunath Gokare from Gokare LPO. Offices in Atlanta, Georgia, USA, and then Bangalore. And appreciate you being an exhibitor at the conference very much. And then myself, I'll join the panel and we'll put on a new hat. Right.
Hi, everybody. We've been listening to a lot of information on H's and L's and lots of stuff, but we're going to come back to you with some more. What we have done is we've tweaked our presentation a bit so that we touch upon issues that have not been covered so far. And though they don't directly fit into our topic, I thought it was important to discuss them, and thankfully my panelists have cooperated and they're going to address questions beyond our topic. Before I dive into the presentation, what I'd like to do is first remind you all about our firm's raffle. If you drop your card into our fish bowl, which is on our table, you get a chance to win hampers of luxury Ayurveda products from Forest Essentials. There's a box for men and women, and then there's an extra box for a woman. So please go out and put your card. So there are two prizes. One is the double box and one is the single box. Please go and put your card so that you have a chance to win the raffle. But if you put your card into that bowl, you also will get a book. This is a book on global mobility that we publish every other year. It's a biennial publication. And the next issue is coming out in 2020. The book consists of chapters. I think our last edition has 27 chapters from 27 countries talking about work permits, introducing social security obligations and tax obligations. And these are authored by legal professionals in each jurisdiction. Our firm is the editor. We author 3 of the chapters, that is India, US, and UK, because we are licensed in those 3 countries. But all the other chapters are authored by legal practitioners in their jurisdiction. So this is the book. This is our last edition. This is our 4th one. We are coming out with our 5th one, April 2020. If you'd like a book, please drop your card. We're going to only be able to send books to the people whose cards we have because we need your mailing address. Thank you. And now we will dive into the presentation, please. So first, so the whole idea of our panel is to see what's... Joseph, I thought we were going to do those 3 questions first. Sorry.
Slido.
Slido.
Yeah. Get your phones ready.
So our panel is all about trying to determine what's coming up in the future. And like I said, we're going to deviate a bit from that. But gazing into the crystal ball, or what is the Powerball, is what we are going to be talking about. And one of the biggest things that we're all concerned about and have no clarity on is the H-1B selection process. So that's going to be something we're going to start off with. Are we ready with Slido? So gazing at the H-1B Powerball. And that's your first question. It's hard to read, isn't it?
Yeah, it's hard to read.
Is the saving of resources, man-hours, printing costs, and stationery for the H-1B cap filing significant for your company? If the pre-registration happens, do you think you all will save a lot by way of man-hours, costs, courier costs, printing, stationery? Perfect. That's exactly what I expect. What do you think, Manjunath? Do you think we'll have a lot of savings?
Thank you, Poorvi. Yes, I mean, so historically, the way the cap season worked, companies would file their cap petitions. The first 5 business days once the cap opens, so April 1st onwards. And if enough petitions were filed in those first 5 days, the lottery would then be conducted. The doors would be closed, and then they would conduct a random selection process, and they would then tell you which cases were selected in the lottery and which cases were cap rejects and would be sent back. So as a result, companies would have had to spend a lot of money in preparing petitions, not really knowing which ones would get selected in the lottery. But with the new process which has been announced, with the pre-registration, companies will have to initially come in. They have to submit some basic information about both the company and also the beneficiary. Yeah. And only if they are selected do they file the petition. And the final rule basically...
We're going to get into that in a bit, but do
yeah.
you think, just to answer this question, do you think we're going to have a lot of savings in resources?
Significant savings for companies, but we will see volumes going down for law firms like all of us.
So we three will lose revenue, but you guys will, the corporate houses will gain in saving costs. So Jake, do you see any other savings over there? Anything else?
The thing that I am concerned is that if they make it so easy to enter into H-1B lottery, there will just be a flood.
Of sham cases?
Yeah, sham cases, frivolous ones, that so many companies can afford to enter into the program that the legitimate ones or the bigger companies would just have their opportunity diluted.
Right. There are two savings that don't have a direct impact on what we do, but has a great impact on our planet. We're going to save thousands and thousands of trees, and we're going to also save on our carbon footprint. The companies that are filing 3,000-4,000 petitions each year, they are spending money on couriers which are being, packages which are being flown to the USCIS. We're going to be saving on that also. So I think all in all, as a humanity, we're going to come out winners. But in the process, we'll have some winners and some losers. The second question, please. So have you received more H-1B approvals? I think we had this question even yesterday, and yes, I was also surprised by the result yesterday. What about you both? Have you seen a difference between FY 2019 and FY 2020 for the period that has gone by?
So we see, beginning in 2017, after the Baha executive order came out, there was a lot of confusion in terms of adjudications. And we see some patterns emerge now wherein, especially in situations involving third-party placement, if you provide them with certain documentation in terms of MSAs and SOWs and work orders for the entire contractual path, and it's well documented and the work orders are for a longer duration, we are seeing approvals. So there is some measure of consistency coming in, especially in 2019 compared to last year. That's been the experience in our practice.
So for our firm, we've not really seen any increase in denials. We've not really had any denials so far. So for us, it's been pretty much what it was last time, though anecdotally from other colleagues, we do hear that they're facing some difficulties. What about you, Jake?
Well, I think like Manjunath said that...
well documented.
Yeah, well, we're finding what is the agenda of Trump administration through time, and the RFEs, the approvals, the questions that are coming up. We're starting to see what that agenda means and how they want to control the approvals. So I'd say from last year, we know so much more now from what we get in the feedback from these approvals or RFEs. So I think we're doing better now with that, knowing the landscape.
So we know the enemy.
Yeah, the enemy is...
The moment you know the enemy, you know how to strategize. The other thing that you all should be aware of as to what is coming, because we are also, we are trying to gauge what is coming. One of the things that is really not publicized too much is how USCIS is short-staffed, and and that's causing the delays, right? We're seeing humongous delays in all categories of petitions. But why does USCIS have such a shortage of employees? They are sharing their employees with other agencies. They're lending them to CBP and ICE because those guys need to do some more site visits and fraud detections, et cetera, et cetera. So USCIS doesn't have enough staff to do their work, but they're loading them to other agencies. So what you can expect is more delays and worse delays. Next question, please. So do you think you will stand a better chance in getting selected because of the pre-registration digital H-1B lottery? 43% think it'll be better, 43% think no, 28 think yes, and 28% think no difference. I think there's definitely going to be a difference. Like Jake mentioned, we're going to have a deluge of applications, and if that happens, then the ratio of the number that is going to be picked is going to be much less in proportion. But the absolute numbers, of course, cannot go beyond the 85,000 that are available. But as per ratio, so how we are just now seeing 1 in 3, 1 in 3.5, you might end up seeing 1 in 5, 1 in 6. In fact, that, according to me, is diluting your chances of getting selected. Jake, do you agree?
I totally agree. I think that I'm not sure who's saying there would be no difference out there, if you're paying attention. There has to be a difference because there would be so many more applications submitted, I think, under this program. It's only $10 to register. Everyone will do it. But because of that, I think it will just be a system overwhelmed, and people that are not qualified, I imagine, will be coming in, and too much competition for the real ones, for the ones that actually can afford it and sustain these workers.
And what this will mean for the smaller companies that do the 10, 20, 30, some companies just do a handful. They're going to have a worse chance at the lottery than the larger companies, because the larger companies will just file 2,000 when they need 1,000 positions and hedge their bet, but the smaller companies don't have that luxury. So I think it's going to be unfair for them. Do you think, do you have any other views, Manjunath?
No, I agree with both of you. It's going to make it harder. Like Jake said, and like you said, Poorvi, there will be a deluge of applications. There's no real consequence in the final rule if you get selected in the lottery and if you don't file the petition. So what is the consequence to the employer? There was some discussion around this in the comments to the proposed rule, but there is really no teeth to the final rule. So a company can come in and file a request for 100 H-1Bs, and maybe 50 of theirs get selected, but they only file 25. So I think it's going to be very disruptive to the process, in my view.
So if you see the pre-registration process, I mean, what is being anticipated is that a lot of pre-preparation will be required. For example, if you have an attorney, you've got to make sure he or she has uploaded their G28, one per company, it's not one per beneficiary. You will have to pay a $10 fee for every pre-registration that you want to do. That's not a big amount of money, but you will also be spending time. And if you have an attorney doing the pre-registration, there will be the attorney cost. But even otherwise, you will be spending man-hours because you want to check the credentials of the employee before you even put it up for pre-registration. Because if you're selected, you have to file the petition. So that becomes, you've got to be cautious about it. The other thing is that each company can only file one petition per beneficiary, and with the online process, they're going to be very strictly monitoring this, and they're going to have higher technical capabilities to monitor it. So, and the penalties are going to be stringent. If they find multiple, all the petitions will be disqualified for that individual. Also, if you have made an error, there's no way you can correct, then you're not going to likely be able to correct it, but you'll have to refile. You'll have to withdraw the application and start all over again. The problem with this is that there's going to be a window when you will pre-register, and you might notice the error when you're preparing your paper application, but you would have lost that window of opportunity to change anything. And as it is, the USCIS is sharing information with other government agencies, but after this online registration system, the sharing is expected to be more detailed. I mean, they're going to have more details that are going to be available to other agencies, and agencies have been given instructions to act upon the findings of this data. So we're going to have more Big Brother watching. the potential heads of information, and we really don't know whether this is what it's going to be. But by and large, what the petitioner has to provide and what the beneficiary has to provide is listed over here. One or two things that we have to be careful about is that the petitioner has to attest, and those attestations have to be carefully done. The authorized signatory must attest to the accuracy of the information and that the company organization intends to file the H-1B petition if selected. So that's a big responsibility. It should be taken seriously. And of course, for the beneficiary, it's going to be regular stuff. The good thing is you don't have to file an LCA before. During the pre-registration period, you can file it if you are selected. Okay, now these are some of the other things that we are going to touch upon today in addition to a few questions. We come to this. This is what we discussed yesterday. There are indirect changes to the way the H-1B program is managed. In my view, the government is doing everything it can do other than changing the law, which it can't do, to make it difficult for the program. So, and I think hearing other panelists and seeing your questions, everybody seems to be feeling, yes, the H-1B program is under attack. Okay, now we come to prevailing wages, and I'd like you to talk about what is prevailing wage. First, Manjunath, if I may just have him walk through what is prevailing wage, and then if you can then help us with how to deal with level 1 wages, because I disagree with some of the other panelists that you should not use the level 1 wages at all. I believe you can carefully use it in certain cases. So if you can help the audience understand what prevailing wage is, just like a refresher, please.
Sure, yeah. Thank you, Poorvi. So prevailing wages are wages which are published by the Department of Labor. They come out every year in the middle of the year, June. They provide data on all occupations geographically, by county, by MSA. You can all go into flcdatacenter.com and look up these wages by occupation, by geographic area. There are 4 levels of wages which DOL publishes. Level 1 is entry level, level 2 is qualified, level 3 is experienced, and level 4 is fully competent. So there are 4 different levels of wages depending on the level of experience which is required for the position. So there was a lot of discussion in one of the earlier panels about level 1 wages and how people were really driving all their petitions into level 1, even though the employee or the beneficiary on that petition should really have been at a higher level of wage, level 2, level 3, level 4. So there is really increased scrutiny from the USCIS around the wage level selection process, and employers are now, and also attorneys are making a more, they're more detailed in terms of the evaluation they do before recommending the wage level and before filing the LCA at the appropriate wage level.
Yeah.
I hope that explains.
Sure, it does. So one thing that I find that companies don't pay enough attention to is the mapping of the SOC codes and the prevailing wage across the employee base. When you don't do that and you just randomly select and you don't have any criteria for your selection, or you don't have a grid to map why a particular person will be at this level or with this SOC code, I think those companies are sitting on a time bomb waiting to burst. It is very important to evaluate what is happening company-wide. But most companies are so pressed for time that they're in a hurry just to get things done. This extension needs to be filed, this cap case needs to be filed, and they do not spend enough time doing an internal assessment across the board. Jake, do you have any views on that?
Yeah. So the LCA that is filed with Department of Labor tells the prevailing wage that the employee should be paid. And as Poorvi said, the company is supposed to look at the wages across all of the employee base to tell the Department of Labor that they're paying the H-1B worker at least as much as other workers in the same job category at the same level, and not paying the H-1B worker any less. I think that's important because in most cases, probably most of you have never seen a challenge from Department of Labor.
It's coming.
Right? How many have been audited by Department of Labor on their LCAs? Not USCIS, Department of Labor. You see, nobody. I don't see a hand going up. To me, this is one of the most obvious places where Trump, if he really wanted to do something, he could go after the LCAs and talk about whether the employers are actually paying the proper wage, if they're doing the actual wage analysis to determine that they are paying the H-1B workers at least as much as others in similar positions. And so many things they could go into on the technical issues around the LCA, but Department of Labor is quiet. You don't see them.
But that doesn't mean it's not coming. I think that it is coming, and you need to be careful about it because you may not have had a full-fledged audit from the Department of Labor, but you are seeing increased USCIS site visits. And remember, they're sharing information. So you need to be careful about that. We're going to deviate a bit more now. Jake, could you explain to us what is an MSA and how does it affect transfers or amendments of petitions, please?
Yeah. So when an H-1B worker is sponsored, the LCA will mention the geographic area where the person should be working. And that's known as MSA. It's a metropolitan statistical area that the government will be using to draw the wages through surveys so they can determine the correct wage within that region. When a worker is assigned to a specific geographic location, the H-1B rules allow that worker to maybe change a location within that MSA without having to file amended H-1B, which is a great convenience if you're moving your office down the street or you just want to assign them to another place, maybe within San Francisco Bay Area or something like that. It could be very convenient, and no amended petition may need to be filed. We should look at each one carefully, but that's one of the exceptions. If the worker will go outside of the MSA, then that may trigger amendment requirement to file H-1B amendment.
Sure. So if they are moving within the MSA, Manjunath, do you need to do anything? Do you need to amend the LCA? Do you need to do anything?
If the employee is being moved within the MSA, technically there is no need for an amendment. There was a case called Simeo Solutions which came out some time back, which made amendments mandatory if the employee is being moved outside of the MSA, like Jake mentioned. But the other concern we have in our practice at least is now the LCA form has been changed, and the LCA asks for the numeric end client in your Part 7 of the LCA. So if the employee was, say, placed at Verizon within the metropolitan statistical area of the Atlanta area, and now the end client is somebody else, say Coca-Cola, I mean, it's still a move within the same MSA. If you go by the strict reading of the Simeo Solutions, maybe an amendment is not required, but with FDNS and all the site visits, we always tell our clients, go ahead and file an amendment, even if it's...
Amendment to for the
LCA
LCA or the full petition? Okay.
If it's a movement within the MSA, but it's a different client, because then the contractual path changes, and who knows, USCIS can come back and argue that that was a material change. Sure. So that's something we advise. Not all the time clients listen to us.
Yeah.
And,
so that's what we
they
see
may
too.
or may not take
So,
our recommendation.
Right. So let's say if he did file a petition to amend and he moved from Verizon to Coca-Cola, when can he start working at Coca-Cola? Jake?
When amendment is filed.
Right away?
Yeah, right away. So usually it takes some time to get LCA approval. Most of you would know. About how long? 5, 7 days, maybe on a good day, 5. So that's about the soonest you could have the worker in the new location.
Right. There were questions from the audience on this, and that's why I brought it up. So let's say this petition is, the amendment petition has been filed. We have a receipt notice for it. He has a valid H-1B visa. Can he use that to travel back to America and start the job at the new work site? Can he do that?
What do you guys think? No.
Sorry?
Yeah.
What do you think?
There are times when the employee has an underlying approval and there's an amendment filed for a change in work location. I would say travel on the amendment receipt. If you have a valid visa accompanying the I-797A, which was issued initially, so long as the USCIS has been notified that the work location is going to be changing and the amendment has been filed, and the employee, like Jake mentioned, can work on the filing of the amendment. There's no need for an approval. So I guess if the visa is already issued, yes.
agree.
I would also say that, but I would also suggest that they take some more documents with them when they arrive at the port of entry, a letter from the second work site supervisor or the end client, a letter from the manager in the sponsoring company, etc. So some more material to support his claim and prep the client, so I mean prep the beneficiary, brief the beneficiary so that he addresses the questions at CBP very adequately. This was one of the specific questions from somebody in the audience. So offline, they brought it up offline. Okay, we just have a little bit more time, but I know, Manjunath, that you had a few comments that you wanted to make specifically. This is your chance. Sorry, did I throw you off?
No, you did not. So the main thing was, I know pre-registration is coming. The million-dollar question which everybody is asking is, will there be pre-registration for fiscal year 2021, which is next April? We don't know the answer to that question. In my view, I think we will know by end of January. USCIS has to create, implement, test, and roll out a brand new system. And the final rule said there's no registration fees, but then within the last few weeks, they said they will have a $10 registration fee. So it may happen, it may not happen, we don't know. Watch out for that, because that is going to significantly change the way H-1Bs are going to be filed for the upcoming fiscal year. So that was the main comment I had.
Sure. What about you, Jake? Any comments that you must make about what's to come or would like to make?
I think I'm hearing so many things that have helped me in this conference, and hearing the feedback from everybody, these good questions. I'm actually feeling good about the program, and the future I think is good. I'm not going to feel negative and
So you're
down.
feeling good about the H-1B program or the INSZoom program?
That too.
Both.
Yeah, especially INSZoom program. No, I'm positive about it. Like I mentioned earlier, I feel like we're finding the limits, and the landscape has emerged through a lot of the questionable time we were facing as Trump came in. I feel like now we kind of know where we stand and how to handle the challenges, and so.
And I like what Anandita kept saying on multiple occasions, that yes, we have a regulatory framework. Yes, we've got to comply with the law. So you've got to play the game by the rules. Just because the rules don't seem pleasant or don't appear to be the same as they were, that doesn't mean we can do things differently. We've got to play the game by Trump's rules. And that's what we've got to do, whether it's pre-registration or not. Thank you so much. I don't know if we have time for questions.
I think we're kind of up. Yeah, but thank you, everybody.
We'll take questions offline. All three of us are going to be here. Thank you, guys, for being a great audience. And thank you, panelists.
Thank you all.
Yep.
Thank you, Jake.
Thank you.
Manjunath.
Manjunath, thanks for joining. Poorvi. And there might be a trophy of appreciation coming your way.